All right. Good afternoon, everyone. This is Kurt Verone. We've got my good friend Bill Macarone here. Brad Pinsky is somewhere in the Bahamas. I think that's where he said, at Jamaica or somewhere on vacation. So, but he said he's texted me this morning. He said he'll be back for next week. So, at any rate, we're here to get started on, actually, we're going to try to do 7. We'll see how it goes, but we've got 7 cases since our last file or roundup. So, Bill, you feel comfortable with the facts?
Yeah, well, did you want to start with Alabama? Because I was ready to go with starting with the case out of Alabama.
I'll start with Alabama. The first case we've got is looks like a small fire department in Alabama that apparently was looking to do some things over the Christmas holidays. They took some Santa costumes to a particular dry cleaner, and apparently when the dry cleaning was done, there was some bleeding of colors or whatever, that the things were damaged. So they got into a little bit of a dispute with the dry cleaner, and the dry cleaner is actually in Florida, which raises some interesting issues. But parts of lower Alabama are very close to Florida, and they go across the border quite a bit like, Bill, not unlike what we do here in Rhode Island, where we're into Massachusetts, into Seekonk for shopping.
Absolutely. East Bay goes right over the line into
right. Sometimes you don't even know what state you're in. So, yeah. But bottom line is, they ended up suing the cleaner in a small claims court. Okay. Now, all states that I'm aware of have a small claims court. Typically, how it differs, usually in small claims court, you don't have a right to a jury trial, and is usually a dollar cap. And the procedure is usually much more relaxed than in a more formal court. So the idea there is that you don't need to necessarily have an attorney. And it doesn't seem like they had an attorney in this case. But interestingly, and Bill, I know you might not have gotten a chance to take a look at the complaint, but I read it. Yeah, the complaint alleges negligence.
Yeah.
What are you thinking in terms of other allegations that an attorney might have added to this kind of a transaction?
Oh, yeah. Well, it was ironic. You were saying that. I mean, obviously, it's a warranty type issue, breach of warranty. Breach of warranty would be my. You're bringing me back to law school now, Kurt.
I know. No, I know. But but you know what? They ingrain that into our brains in law school so that you don't get fixated on one thing, just negligence. And I think they got some breach of contract, breach of warranty,
contract,
and maybe some other state law claims that may or may not exist. I don't know. So, but in small claims court, the judges are pretty flexible. Much more so than they would be in a more formalized court. So, we'll see. They're only seeking, I think it's a total of
$1,600, $1,600 in damages.
Costs, so.
Yeah.
So we'll see. I mean, certainly not an earth-shattering precedential type of case, not, the type that's going to the U.S. Supreme Court, but, we don't want to ignore the small ones from time to time either. Okay?
No.
So,
and it was interesting they went to small claims, like you said. It was interesting that they went across state lines, because obviously that was as part of the issue. You're not going to be able to sue them in Alabama. The dry cleaner is not in Alabama unless So no, you're absolutely right.
Well, it's interesting because here in Rhode Island, I would feel comfortable knowing what court it needs to be filed in, and I know you're an attorney in Massachusetts, but if I had to file a small claims action in Massachusetts, I wouldn't know where to begin. I'd have to research it. Same thing in Connecticut. You get used to working within your own state. And now you've got non-attorneys. They've got to figure out, am I even in the right court?
True. Very true.
So,
very true.
Yeah, the other case, the next case here, it involves a Georgia fire chief. And I feel kind of bad about this one. I don't know.
I do as well.
Really, yeah, I don't know what's really going on, but the chief of Peach County, and I'm not sure if he retired because of this. Some of the news media said he's the former chief, but apparently 6 times he used his county credit card to put fuel in his personal vehicle. Now, there's reasons why someone may rightfully put county, pay for because if they use their personal vehicle for certain things, maybe your city vehicle's broken, or maybe you're going out of state to a Chiefs conference that's, work related and so on. So,
I felt the same way with this one. I really felt the same way. I felt as if, especially the fact that I understood what the county prosecutors were saying, as far as, this is it impacts the public's trust in public officials. And I get that, but I also look at $229 over the course of 2 years on 6 separate occasions. And I thought exactly what you were thinking. Well, maybe the county should have a policy that if you're using the card, you have to kind of document why you're using the card, and right. And because it wasn't charged with falsifying documents to and you kind of read it, there's no charge of falsifying documents to the county and saying that he went and put gas in a different vehicle when it was actually his personal. So I think there's a lot more here.
And to me, when someone does something like that, they act as if they weren't doing anything wrong. That's an indication they didn't think they were doing anything wrong, So who knows? Now, maybe there's a lot more to it. I know the Georgia Bureau of Investigations, the GBI, did an investigation. So at some point, we've got to assume that there was some objective eyes on this, and they still felt that there was something there. But I don't know. I hate to bury stories. I hate to not cover stories. Some stories, I think, they're legitimate. The charges in the cases are legitimate, and some I just kind of scratch my head. And I hate to personalize or editorialize when I post the stories, but certainly a forum like this, or certainly in the comments to some of these, I'm willing to share my personal views a little bit more. And I just don't know about this one. That I'm kind of troubled by it. Also,
he was released on $10,000 bond, I believe, and I don't know why this would be a recognizance. I mean, I don't understand that. So it's a different area of the country, different. I don't know. I think there's more to this, personally.
Yeah, and there might very well be that we just don't know. So, but it's unfortunate. And all right, next one. Hey, this one's right up your alley. We got an overtime case. All right.
Yeah.
You've been following this case, right? The Encinitas.
Yeah, it was one of several white collar overtime exemptions. And basically what that is that's that complete overtime exemption that, like, typically a fire chief, maybe an assistant fire chief that works Monday through Friday, squarely falls in. And it's an exemption from any overtime pay. And obviously where the line gets drawn, or where you start to see these battles or, legal issues, is when you start applying that to folks that work on a shift and are in the term we use as first responders, that are a potential first responder. So here, this is a lawsuit was filed by 4 battalion chiefs. 2 of them were former battalion chiefs. 2 were current, still with the city of Encinitas, California. They basically were treated as exempt employees, and the 4 of them thought that was wrong. So they opted to file the lawsuit. So in the end, it wasn't a trial. They ended up settling it, as is very typical in these types of cases, these types of situations. They settle it for $145,000 in damages, which, as far as the settlement is concerned, it looks as if that's right around what they would have been owed if they were treated as overtime eligible. So it was no liquidated damages, because that was kind of the claims, where they were going to get around 150,000 in back wages. And then typically under an FLSA action, there's that equal amount of damages that are applied. So it would have cost the city, in theory, if they lost at least 300,000 or right around that area before you begin paying attorneys and all sorts of stuff like that. So here they agreed to the settlement, 145,000 plus another 25,000 for the attorneys that represented the battalion chiefs. And it looks as if, and it's not clear 100% from reading the settlement, but it looks as if they're going to be treating them as non-exempt moving forward, because there was an additional, the very end of the settlement documents, there was an additional line that the 2 remaining battalion chiefs were going to get some retroactive pay back to January of this year. So my thought process is that retroactive pay was 1/2 of their regular rate for all scheduled hours worked between the signing of this agreement and last January, or I'm sorry, I believe it was up until last January. So the end of last year into January. So what that led me to believe is it's not in the documents, but I think that they kind of made those folks non-exempt moving forward.
Yeah. Yeah, that was my guess. And I actually was looking around for any clarity on that, but
No,
I didn't
couldn't
see
find
anything.
it.
Yeah. So, and that always remains a question, because if the community settles the case, but then they don't change going forward, they're opening themselves up to the same suit in a couple of years, or maybe even sooner.
And it's truly a lot, and a lot of times, one of the things that the court examines in any FLSA settlement is whether there's a true dispute here. You know, whether there's a real, is this a slam dunk? Are the employees correct here? Is the employer correct here? Is this a slam dunk? This is one of those where the settlements here are common, and quite honestly should occur, because it is truly based upon the facts, and it's truly it could go either way.
Yeah, I quoted extensively from the judge's decision so that folks could see how the judge is going to be looking at it. And you'll notice there, if you're not really tuned into what the judge is doing, the judge here is trying to show that there is a controversy. He's not trying to rule one way or the other. He's just trying to point out that there is a controversy. And so what, typically when we see a decision, the judge is saying, this is why I'm ruling in a certain way. Here, the judge is just pointing out both sides of the argument and saying, yeah, there's a fair dispute here. Therefore, I have jurisdiction. I think both sides are reasonable. Therefore, the settlement is reasonable. Yeah. So cool. Next, we're flying through these, Bill.
No, Nashville.
Oh yeah.
Yeah, and obviously this was, I did in reading your coverage here, Kurt, I did chuckle when I saw that, that one of the defendants in this lawsuit was the other person who hit the plaintiff, which makes sense. I get, everyone's going to get dragged into it, but that person really should have paid better attention and not hit them. The driver of the vehicle. Well, let's back up to folks. That didn't read.
Well, let me back up, because I started out by saying that I don't like to editorialize, right? Yeah. And here I am editorializing, but
but when I read the complaint, I thought the same thing. There was a motor vehicle accident. What appears as if from the complaint, and obviously the complaint is that the plaintiff side of the story, something came off of a Nashville fire truck. Whether it was identified as possibly a hose, possibly a piece of equipment. Correct? I mean, it was really that was even vague.
It was kind of vague, but I'm assuming it was probably a hydrant appliance attached.
Like you would think it would be
to that,
but it was rather vague. But something came off the truck. As a result of that, this woman, Kristen Bozen, I'm not sure if I'm pronouncing that correctly. She hit whatever came off the truck, and whether that was avoidable or not, whether it was negligence or not, who knows? Like we'll figure that out. But obviously, and then in the result of her hitting whatever came off the truck, allegedly, another vehicle must have run into her. So now we turn around and this young lady is suing the city of Nashville and the person who hit her. And basically the suit is alleging negligence in the equipment and negligence in the training. Apparently, the firefighters didn't know they should probably strap that stuff down, and all those great arguments I'm sure will be made. Yeah. Or there might be a settlement. I don't know about that.
You would think the insurance companies would have resolved this before it even got to the litigation stage. But I think it is kind of ironic that she's alleging the driver that hit her from behind failed to keep a proper lookout. But apparently she wasn't under any obligation to keep a lookout
to do the same
things that may be in the road in front of her. And oddly enough, now you think about it, I mean, I don't know about Tennessee law, but I know here you're not supposed to follow 500 feet behind a fire truck. Okay. And that they don't have to be displaying the red lights or anything. You have to keep back from an emergency vehicle. And there's no such obligation when it comes to a civilian vehicle. So she was under a greater obligation to stay back away from the fire truck than the civilian that hit her. So there's a little bit of hypocrisy and irony in the complaint there. So
and this is a little just the facts I think I find and a little bit comical, just as and obviously someone could be injured here and the property was damaged, etc. And there's been tragic accidents related to equipment coming off. You know what I mean? In the past, not very often, but there has been at least one instance that I'm aware of. Not that long, and correct me if I'm wrong, Kurt, was there a video of a line? Wasn't there a line? I mean,
there was a gentleman in Now I can't remember one of the cities. I've got it in my database in Massachusetts that was severely injured, and then there was another video of a woman in Cambridge that was killed.
Yeah.
And those, oddly enough, those were Matty Dales crosslades that came off, so they were attack lines. This one, it's not clear whether they were attack lines or the fact that
it could have been anything. Could have been a helmet.
It could have,
I mean,
well, it's when it said equipment, I'm assuming it came off the tailboard. It was probably, I mean, I know many departments have the
hydrant bag
supply line, all hooked up. So I'm assuming that it was some sort of appliance that was attached to the feeder line, but it could have been an attack line. And I know we got a little bit of a problem here with attack lines in particular, because if you look at some of the marketing for attack lines, they emphasize, it comes off easy, and it's less friction and can be operated by fewer people. All the marketing angles of making a hose that is not going to have a lot of friction in it. Well, guess what happens?
It comes off easy.
It comes flying off. You go around a corner too quick, and it's not secure. And another reason why the NFPA has, mandated that we have some closures on these hose beds to prevent the hose from self-deploying. If it could only be that easy when there's actually a fire, if it could self-deploy, but at any rate, but you're right. I've got 3 fatal cases, lawsuits, and I know I had to investigate this when I was with the NFPA. There was a concern that actually the Cambridge case really brought it to the forefront, and Randolph, Massachusetts was the a location where there was a gentleman injured, Randolph, Mass. I did not see a civil suit by the person who was injured against the fire department, but there was, I believe they did sue the, I think it was Pierce. I think it was a Pierce engine. So they sued Pierce, but I did not see a suit against the Randolph Fire Department. But point being that there are these types of things that happen, and not every day, but they do happen. And when I was with the NFPA, I went to the firefighter close call website and just put in a hose. I forget what I put in: hose self-deployment or hose coming off truck. And there's a bunch of them in the close call database. So it is happening. And so. All right. Next,
San Fran. Right, moving out to San Francisco. I tell you, I read the headline here, and I kind of thought, how is somebody going to sue the fire department for an off-duty assault? And then I started reading it. I said, okay, I see why we are able to realistically grab all those folks. This is a tough one. This is a very difficult fact here, I think.
Yeah, it is. And, we've got a San Francisco firefighter who was, according to the complaint, he was assaulted and pretty much beat up by a colleague. And apparently there was some sort of workplace dispute that carried over to off-duty activities. But this one particular firefighter had apparently made some threats, and he took what they call a spanner, which I guess is their version of a hydrant wrench. But he left work when he got relieved, left work, took a spanner, and then I guess pummeled this guy. So now the victim, the person who was injured, has sued the fire department and sued the firefighter. And there's some factual questions. Again, a lot of things I don't understand about San Francisco and how they operate, but apparently what they're saying is the person who was the aggressor was never disciplined or was never formally dealt with. And I don't know whether that's true or not. I find that hard to believe. Yeah.
No, and I think there's another, for me, at least when I was reading the facts, another key fact was that the defendant, the person who did the assaulting, got the plaintiff's address from the computer system at work too. So I think there was a number of just that, and I don't know, especially when you look at what happened in California, and that was at LA County a couple of years ago that had
Yeah, they did.
murder suicide in the house. And I mean, just we really, this is obviously any fire chief's nightmare. I would imagine. I'm not a fire chief, and you've you've been higher up the chain than I have, and obviously this is
bigger target. I got a bigger target on me than you. So, but
No,
yeah, these things are happening, and OSHA requires, not all fire departments fall under OSHA, but OSHA requires that you have a workplace violence policy. And that, we've got to make determinations about whether or not there's a direct threat to the safety of an employee, and, how are we going to deal with it, and all that. So, and again, we're hearing one side of this. We don't know all of the facts, but it certainly is concerning. And, whether or not the fire department will ultimately be liable, that's a whole different aspect in terms of, whether or not they were in a position to recognize this and prevent it from escalating to the point where they had violence.
I mean, under ordinary circumstances, what I would say, and I consider an ordinary circumstance of two firefighters, a firefighter assault on the other, I think of at a bar over a pool table one night after a fundraiser or something. That's what comes to my head. The fire department typically isn't going to have any, it's out of the fire station. It's separate. These two had an argument. They settled it, whatever. But obviously these facts are much different. At least the allegations are much different.
Yeah. And one of the things I recommend in our hazing, pranks, and bullying policy, harassment policy is, you can't stop an employee from doing things off duty. Okay. There's a constitutional issue, due process issue, and so on. So, but you can where there's a connection to work. So, for example, you can't prohibit somebody from harassing a neighbor. Okay, you can certainly prohibit them from engaging in illegal conduct or, conduct unbecoming, which is kind of vague there. But you can't say you cannot harass or bully a neighbor. It's got nothing to do with work and so on. Okay, but you want to make sure that in your policies, you say that you cannot harass or bully a coworker on or off duty. Okay, and that's important in a couple of areas, because we are seeing cyberbullying, and I'm going in social media direction here. But we have seen cases where firefighters are harassing people in the station, but then also doing it off duty. Absolutely. And they're doing it through social media. They're doing it through other channels. They could be on the same softball team or bowling league or golf tournament, or whatever it may be. But what we want to make sure is that from a fire department's perspective, that we can protect our employees, that we have the rules in place so that when someone engages in this kind of behavior off duty, we're not trying to charge them with conduct unbecoming, because, this one here, although he was charged criminally, so that, hopefully they have regulations about off-duty criminal activity and prohibiting that. But if you have that ability to control them, and again, you can't control a firefighter in terms of what he does off duty with their neighbors or friends or colleagues, well, not colleagues, but you want to have the ability to do it with other members of the department.
Yeah. And also the cyberbullying, there's a lot of recent criminal statutes that are aimed at the cyberbullying. And that's a link to it as well, that you can, and I know I've seen some policies, some of those hazing and bullying policies that have linked, those criminal statutes in the individual states, because if it's illegal to do something, especially if it's illegal to do something, via text message, why should it be okay to do it face to face while we're sitting across the table from each other?
Right. Yeah, and those would be generic, so that would be applying to everybody. But we want to make sure in the policies we have, especially I think our hazing, pranks, bullying, social media policies prohibit harassment and bullying of colleagues on or off duty. Yeah. So, all right. And the last
LA
one
County. Here. That's is it the end? It's just I think it's the end. I think it's the end. I haven't stopped to count how many times we blogged about this particular one, but this is the Vanessa Bryant lawsuit against LA County, because mostly sheriffs, but there were some firefighters who took some pictures at the Kobe Bryant helicopter crash of the dead bodies.
And, that incident had a number of impacts in California. First and foremost, they enacted a criminal law that, made it illegal for first responders to take and share those kinds of pictures of dead bodies. But there's been several lawsuits. I think, according to my count, there was a total of 5 lawsuits, and there may actually be more, but 5 against LA County Fire, or LA County on behalf of the fire department, arising out of that. And this is the largest settlement. She had been awarded $15 million in damages. I guess I'm not sure how it got up to $28.5 million. I don't know if that's interest and attorney's fees, or maybe it's just to make this thing go away, but they ended up giving her 28.5 million, maybe to prevent it from being appealed. I don't know. Any thoughts on that, Bill?
No, and I want to say because I was reading the article. I read this one last night. I was going through, and I'm trying to recall if it was. I don't know. I don't know why they did that.
Maybe there might have been some state law claims that weren't addressed in the verdict.
I'm just looking quick. I'm sorry, I don't know.
I don't know either, but the jury awarded 15 million. And there was 4 lawsuits by the victims' families, the people who died. There was 4 lawsuits. The Bryant family got the largest. That was 15 million. One of the other families got like 13 million, and the 2 of the other ones were settled for 2.5 million. They didn't go to trial. So at any rate, certainly in a case like this, is often appeals, and rather than have the potential for additional litigation in this, the county apparently just said, look, 28.5 million, and this.
It resolves. I just found it. It resolves all outstanding issues related to the pending legal claims in both federal and state court, and future claims by the children, other costs, et cetera, attorney's fees, et cetera.
So, I try to stay on top of this, but I have a life. I have other things I've got to do. I've got clients and obligations. And so, there may actually be a bunch of cases in state court that I have not been able to access. But the ones that I have seen, there's a total of 4 from the victims, 1 from an LA County firefighter who was disciplined over this, that's suing, saying that they shouldn't have been disciplined. So, and there may be several other cases out there as well. Okay. So that I believe is going to wrap us up.
We ran the gamut. We started with the Santa Claus costumes. We went to the poor chief in Georgia, and I do think I feel bad for the facts, certainly. And then we got to progressively just kind of worse things, fortunately.
I think that's the Vanessa Bryant case is certainly one of the bigger ones in the last few years involving the fire service. And, just another reminder that we've got to have good policies when it comes to picture taking and sharing and social media. So both digital imagery and social media, we've got to have good policies, and we need training, and we need supervision. Enforcement, right? So it's really, I call it the 3-legged stool, because you need all 3 legs. And if you're short, like you think about a 3-legged bar stool, if you only got 2 legs, it's going to be wobbly, right? So you need the policy, you need the training, and you need the company officers and chief officers that are going to enforce it. Not necessarily in a heavy-handed way, but that folks have got to understand that, look, you've got to comply with this. That we can't keep paying out 8.5 million. That's 20.5 million that can't go to firefighter raises or new fire trucks or new hose. That's unnecessarily wasted money. So
that's very true.
Enough of my pontificating. All right, Bill, thank you. Thank you very much. And we got our FLSA class coming up in a couple of weeks. So April 4, 6, 13, 15.
The 2-week, that 2+2 schedule works out. It seems to be working out really well.
It does. I think the feedback we've gotten, folks really like that. And so So certainly if you got FLSA questions, please, think about joining us for that class. I know we both end up fielding a lot of questions day to day from different people.
Yeah.
And we can tell, for the most part, when people have been through the program and when they haven't, because and really how much work it is for us to try to bring somebody who hasn't been through the program up to speed on this versus the folks that have been. So it'll put you up on a level where you're in a good position to communicate with your attorneys on these issues. And also we get a lot of attorneys in the class, payroll people and finance folks as well.
Absolutely.
All right, man.
All right.
Bill, thank you very much.
You're welcome. Thank you.
And that's going to do it for another edition of Fire Law Roundup.